If you could all give me a warm welcome for Matt Harris. He's our first presenter. Matt's goal is to really help people protect their family and preserve their legacy. Whether you need help with an estate plan to protect you, your family, or your pets in the event of your incapacity or death, or whether you need help with a conservatorship to protect a frail adult, or whether you are dealing with the recent loss of a loved one and need help with a probate or trust administration matter, the law offices of Matthew W. Harris will guide you through the complex legal process.
Yeah, great. I am Matt Harris. I am a probate attorney here in Marin County and Contra Costa County. I only do wills, trusts, probates, conservatorships. I don't do criminal defense. I'm not a family law attorney. I'm not a bankruptcy attorney. I have an LLM in estate planning, trust, and probate law, which is a master's of law in that probate code. Yeah. Turn the lights down, sure. Yeah, there you go. Oh, great. I like to walk around a lot, so.
You can. But once in a while, it's just so people can see you.
So I'm here today to talk about estate planning, why you need an estate plan, and the problems that can happen if you don't have an estate plan. So, go a little quicker first. So the big three areas I'll be talking about is estate planning, like what is estate planning, the typical estate plan documents that I prepare, what happens if you don't have an estate plan. We'll talk a little bit about conservatorships. What is a conservatorship? The two types of conservatorships. And probate. I'm sure everyone in here has heard of the word probate, right? And why you want to avoid it. So a disclaimer, I am a lawyer, so I'm assuming no one in here is an attorney. So whatever I talk about today is not, oh, one attorney, okay. So whatever I talk about today is not legal or tax advice. So don't, take what I say and run off and try to create your own thing. When I do an estate plan, it's very fact intensive. So an estate plan, you can't put into a box. Obviously, an individual is going to be different from another individual. Married couple might be different from a different married couple. So generally speaking, this is just for information purposes only. So estate planning is an umbrella term that we use that covers different types of instruments. We have wills, you have revocable trusts, you have advanced healthcare directives, you have power of attorneys. There's a plethora of instruments that we use to protect your family, your loved ones, and even your pets. So the typical type of estate plan documents we just talked about, skip that. So individual estate plan package is around about 10 documents. A married couple is around 12 to 13 documents. Okay. Oh, okay. And remember, we'll email you a copy of the slide, okay? And so I would like to back up a little bit. I don't want this a one-sided conversation. So if you have a question, raise your hand. I want this to be interactive. I don't want it to be boring. Because what I normally do later on, but I'll do it right now. So who in this room knows with 100% certainty that he or she will eventually die? That's everybody, right? So the big question is, who knows when they will die? Yeah. Oh, what, really? Okay. So most people don't know when they will die, and a lot of people don't plan their estates. And so I can get into I will get into some stories later on. But the big three areas that I see are people that have no estate plans, or they have an inadequate estate plan, or they have outdated estate plans. Conservatorships. Anyone ever heard of a conservatorship? So only thing I do is I do estate planning, I do conservatorships, and I do probates. That's all I do. It all stems from whether somebody had an estate plan or not. So a conservatorship is basically when somebody needs to be appointed power of attorney over somebody else, but they need court approval. So there's two types of conservatorships. Oh, sorry, do you have a question?
In place Supposing you have a power of attorney in place, does that constitute not needing a conservatorship?
Yeah, that's a great question. We'll get there, but yeah, the purpose of estate planning is to avoid conservatorships and to avoid probate. And I have a slide on that shortly. So there's two types of conservatorships. You have a conservatorship of the person, which is your obviously your body, your medical affairs, and you have a conservatorship of the estate. So somebody had to deal with somebody's finances. So if you're 18, you're legally an adult here in California, and you become incapacitated, and you don't have an advanced healthcare directive or a power of attorney or a trust, you might end up in probate court. So the examples of people are conserved are usually like an elderly person suffering from dementia or Parkinson's. But I have dealt with young people in their 30s and 40s who suffered a stroke, got into a car accident, and they didn't have a simple advanced healthcare directive or a power of attorney or a trust. So we end up in probate court trying to get a conservatorship. And sometimes I get some really interesting cases, like, for example, if a person's 21, 22, and they're suffering from severe anorexia or drug problems or bipolar. I have gotten conservatorships in those particular types of cases, but it all depends, right? So why you want to avoid conservatorships unless you're what? The attorney. Because as a conservatorships, I can make a lot of money. I don't like to, but if you look at a conservatorship, like a typical 40 hours in a conservatorship, you're looking at about 25,000 in attorney's fees. And so when you file a conservatorship, it's very form driven. There are a lot of documents. Because in a conservatorship, you're taking away someone's fundamental rights. So the courts want information on everything. So there's about 20 different type of documents when you file a conservatorship. And that's a conservatorship that's not contested. I probably deal with half of my conservatorships are highly contested. So that's where a family member objects to a conservatorship. We end up in court. We're litigating, going back and forth. We're doing mediation. We're doing depositions. It's not fun. Probably one of the biggest reasons why you want to avoid a conservatorship is everything you file with the court is open to the public, with the exception of certain medical confidential information. But if you have a family who's dysfunctional, there's a lot of fighting going on, all that is in a public pleading. And so people go down, they review the files, and all your information is open for the world to see. So probate usually happens when somebody with a will or without a will dies, and there's property that needs to be legally transferred. That's all probate is. It's not a very complicated term, but it can be. It can be because we don't know who the heirs are sometimes. We don't know who the beneficiaries are sometimes. And like conservatorships, a lot of probates are hotly contested. If somebody dies, and believe me, some second or third cousin will come out of the woodwork that was around 30, 40 years ago. So like conservatorships, probates are very expensive. So in Marin County, pretty common to have $1 million probate estate. Because most people have homes that are worth at least $1 million here in Marin. So $1 million probate estate, you're looking at around 45,000 in attorney fees and executor fees. So probates can be very expensive, and again, they're open to the public. So like I said, probate is a very open process, open to the public. Usually, like a loved one passes away, you file pleadings in court, and about a month later, that grieving family members will get bombarded with phone calls from realtors, from people who are just trying to sell the homes. So it's not fun. Any questions so far? Oh, no.
open? Are these probate proceedings, are they open to the public for somebody just to come in and sit down?
Public, going to court is open to the public. Like here in Marin County, our probate calendar is tomorrow at 9 o'clock. The probate matters are 9 o'clock, 10 o'clock, conservatorship matters at 1:30. So anyone who has a First Amendment right can go in and see what's going on.
Are these ongoing weekly or is it every day or what?
Week in Marin County, it's every Thursday.
Every Thursday.
Every Thursday, yeah. Sonoma County is usually every Friday.
Oh, I'm sorry.
Sonoma County is every Friday.
Okay. So I'm just kind of curious in as far as what goes on to these things. So I may want to just go down there and just sit in on it.
Yeah, go to any Thursday at 9 o'clock, Marin County Superior Court, and you'll see some stuff that can be entertaining. You'll see stuff that's really sad. One of my favorite courthouses I like to attend is LA County. You'll see some wild stories down in LA. People coming in with the will right there at the courthouse. Oh yeah, my aunt died. Here's a will right here. Other people thought there was no will. So you'll see a lot of entertaining stuff in probate court. If you want to go.
It's just as a curiosity type of thing. I mean, I hear these things. You never want to go through probate. And I that's it. It's just words to me.
I have a hotly contested conservatorship matter tomorrow at 10 a.m. So if you want to see a good show tomorrow, I'm Marin County Superior Court, Department C. You'll see me.
Department C.
Yeah, C. Yeah.
Okay.
I might talk about that story later on, but yeah. So, like Benjamin Franklin said, if you fail to plan, you're planning to fail. Right? So I kind of want to give you like a global view of what estate planning is, why you need one, because I want to talk about the problems of estate planning or not having one. I've dealt with people in their 30s, 40s who were comatose. So they end up at Marin General Hospital. They didn't have a simple advanced healthcare directive and they're on life support. Was a mother of three young kids. She was about 32 or 33 at the time, and she was on life support, and she was a victim of domestic violence. And so under the probate code, the husband, which she was married at the time, has a highest nomination. So if you lose capacity, state of California says husband's number one, your parents are number two. So I went in, told the judge what was happening. I represented the mom. So I got the mom appointed conservator of the person, right? We were dealing with the lady's body. It was literally on life support in Marin General. So I got that granted. And a couple of weeks later, I had to go back into court to get powers to give my client so she could pull the plug on her daughter because her daughter was basically brain dead. So it was a lot of litigation in a short amount of time. It was that very famous Terry Schiavo case that happened in Florida. So remember Terry Schiavo, like 20-something years ago? Terry Schiavo created the need for all these advanced healthcare directives. So I call that my Terry Schiavo case here in Marin County. And so at the time when it happened, we literally had a brand new probate judge. I remember her saying, "Hey, Mr. Harris, can you approach the bench?" I'm like, "Sure, am I in trouble, right?" So I walked up and she was whispering. She's like, "I'm new to probate court. I don't know what box to check." And so this was one of the first cases I gave her. "Hey, Your Honor, you give me my client authority to pull the plug." So it was a sad story that didn't end there, quite frankly. But all that could have been avoided if she simply had an advanced healthcare directive. So I named my mom, my agent, here's my organ donations, here's my end of life decision making. So that was one of my sadder stories. So I do two big areas. Most people think estate planning is when somebody dies, but nowadays that's really half the battle because people are living longer and they don't have the necessary documents. So they're becoming incapacitated. And I get the phone call at least once a week of, "Hey, my mom who's 90 something needs a power of attorney." And I'm like, "Okay, how come your mom's not calling me? Why is the son or daughter calling me?" So that's a red flag for me. I do a lot of financial elder abuse litigation, so that's a red flag. Then I'm like, oh, okay, how's your mom's capacity? Oh, well, she doesn't know who she is. So obviously, I'm not going to go up to an elderly person and sign this contract. Hey, you sign this. They don't know what they're understanding, right? So there's different levels of capacity. I don't want to bore you, but you got testamentary capacity, which is a very low capacity standard. You have contract capacity. So if you're going to sign a 10-page power of attorney or a trust, obviously you need a higher level of capacity, right? So that's one of the biggest areas of litigation in California is usually, I like to call Ethel. Ethel has the trust and she amends it 5 times. And the Fifth Amendment happened maybe a couple days before she died. Gives everything to the neighbor, right? So that's a big area, especially in Marin. So a lot of trust contests are happening right now. And so one of the things that I kind of put myself on a pedestal is I do a lot of litigation and I do a lot of estate planning. So all the problems I see over here in court, I come over here and I put them in my documents to avoid those problems. So a lot of estate planning attorneys don't do the litigation side and they don't see what's going on, all the problems. Like for me, like if I have somebody comes to my office and they want their son or daughter to be co-trustees, I say no, because that's another big area of litigation are co-trustees, siblings who hate each other. So they're not going to be co-trustees, right? Because if you have 2 and they don't get along, there's going to be a stalemate in the court. So you need 3 co-trustees. I don't recommend that. That's just my preference. Any other questions or? Yeah, sure.
Well, Michael, I'm just going to back up to the question before people who need to have your directive.
Mm-hmm.
Do any of you guys have grandchildren? Any of them just 18 years old? Okay. So my son's going to be turning 18 in May next year. And at that point, I could no longer be able to go in and get any medical information nor advocate for him. That's one thing that I've talked with Matt about over the years. I'm like, I tell every one of my kids that are turning 18, I'm like, make sure you have something down and ready to go because they're now an adult. Right? So that's why I have grandchildren. The important thing.
Yeah, I started doing that recently. I mean, a lot of kids up here, they go to college down south and vice versa. So if your kid who's 18, your baby is legally an adult. So if they get into a car accident down in LA, you can't call the hospital and get information because all the HIPAA privacy laws kick in. And so I have done advanced healthcare directives for kids going off to college, and it's very fun to have that conversation with 18-year-old, hey, burial versus cremation, what do you want? They're like looking at me. But it's good. It's good at a minimum that they have an advanced healthcare directive and a financial power of attorney. So any other questions or? Yeah.
This is along the kind of lines of what you're saying about 18-year-old being adult type of thing. So let's say we've set up our estate planning trusts and things of that sort, and we leave our assets to our kids. They're adults types of thing. So how or can this estate planning document or trust or whatnot prevent them from being sued or lose my inheritance to them?
That's a good question. I always tell people the hardest thing about estate planning is just filling out my questionnaire or any questionnaire. My questionnaire is around 12 to 15 pages. And so I go very detailed in people's lives. So I ask, hey, the kids that have drug problems, alcohol problems, are they good with money? So I ask all these questions and I try to tailor an estate plan for those needs, right? So obviously, if you were to pass away, you don't want to leave all your money to an 18-year-old. They're gonna blow it, right? So you could stagger your distributions at 21, 25, 30, or 35. You can give the trustee authority to withhold money if the beneficiary has drugs or alcohol problems. So whatever your situation is, we can craft a remedy for your particular situation. You can do anything in a trust so long as it's not illegal. So you can write any terms that you want. depending on your family dynamics.
I'm presuming there's many different trust attorneys, and they have different ways of thinking about things and such. Would you venture to say that many of the trust attorneys have us as clients interest in hand to kind of get to these nuances?
It depends. I'm a lawyer, right? I always say it depends. Obviously, there's a lot of online stuff. Create your own will, create your own trust. Those are more general. They're not very fact specific. Me, I get really detailed, and I have the litigation side, so I see both worlds. So for me, I've been around for 13 years on my own. I've never been sued for malpractice. I'm very type A. Um, I don't create a cookie cutter type estate plan. And so there are attorneys that do that. There's bad apples in every profession.
Sure.
But yeah, and at the end of the day, you get what you pay for. So if you're paying some attorney $500 for a comprehensive estate plan, it's probably not going to be that good.
And I'm not.
Yeah,
I'm,
yeah.
I'm not speaking from
It's a-
that
It's
standpoint.
it's an amazing. I can have people worth millions of dollars. I had a client. I used to volunteer at whistle stops, and a lot of my clients or a lot of prospective clients, they tell you some funny stories. And I remember one is for low income seniors, right? So she or he gave me the address to the house. I remember looking it up. I'm like, I'm sorry, this house is in Belvedere. It's like worth $6-7 million. Is that your house? She's like, yeah, that's my house. I'm like, well, why are you here? So, it's hard, and I deal with a lot of people who have a lot of money and they don't want to spend money on a estate plan. So I always tell them that's fine, because some of my best clients are people who don't have an estate plan or they try to do it themselves. So you do it themselves, they mess up, then they die, become incapacitated. It's a lot more to go back to fix that problem. But for me, I do this for a living. I have malpractice insurance, so my trusts, my estate plans are basically insured. So that's why my questionnaires are so detailed.
Well, I would expect any trust attorney to be that has would have these things in place so they don't get sued. And I'm looking after your interests because I want your business and future business and so on and so on and so on.
And it's like doctors. I'm telling young doctors to get into geriatrics, and because there's a huge elder population. Same thing for attorneys. There's not a lot of attorneys going into estate planning, elder stuff like that. Yeah. Mm-hmm. So I think
Her question was, why would somebody be a trustee or an executor get sued? Is that your question?
You're the beneficiary.
Or the beneficiaries?
or both. Yeah, I represent trustees, and if you have a trust and you have a trustee is a fiduciary. So the trustee, whoever that person is, a surviving spouse or a private individual, that trustee has to read the trust document and follow the terms of that trust. That's a fiduciary. So what I see is family member trustees have all the power, but they don't know what the hell they're doing. It's a very dangerous combination. And so that's why I go to court a lot, because I sue to have a trustee removed or I defend a trustee. And so those are complicated, like litigation type cases, but a trustee is a fiduciary. So it's like an executor of a will, a trustee of a trust, they're the same thing, they're fiduciary. So anyone can get sued. So I always tell people, hey, I want to be a trustee of Matt's Trust. I'm like, you really want to be a trustee? Because you're a fiduciary and you basically have a bullseye because every beneficiary is looking at you. Don't spend too much of my money. Make my distribution.
I have a question, Matt.
Yeah.
You kind of alluded to something a little bit earlier, but what if somebody has a person in their family or maybe a distant relative they want to make sure does not get part of their estate? Is that something that gets written into the will, or how does that work?
Yeah, if you have a trust that names beneficiaries and it includes 100% of your property, that usually protects you. But if you want to disinherit a child, yes, you put that, I intentionally and knowingly disinherit Brian. Brian's been a bad kid. I haven't seen Brian in 30 years, just to make it exclamation point. So Brian can't challenge. A lot of the older attorneys, they still do it. I don't know why they do it, but like if Brian challenges my trust, he only gets $1. What's $1? It's nothing, right? So he's going to challenge the trust anyways. So a smarter attorney would say, okay, if Brian contests my trust, he's going to lose 100,000. They give Brian something to think about, right? Would you rather lose 100,000 or $1, right? Because $1 basically disinherited anyways. 100,000, you got to get someone to think. Yeah, it's a good question. Any other questions, or you're kind of quiet? You're like, slide 2.
One thing on.
Slide 17. What do you mean by detail?
Somebody had told me, since I'm leaving our home and cars in our trust, that you also have to leave your home insurance and car insurance in your trust. Is that correct?
It depends. When I look at someone's estate, I look at all their assets, I look at all their liabilities, and I try to figure out how to title certain things. A lot of your assets you want to put into the trust. There's certain things you don't want, generally speaking, you don't want to put in your trust, like retirement plans. It's ideal to have a natural beneficiary retirement plan versus having a trust as a beneficiary. Generally speaking, you don't put a car in a trust unless it's like a Bugatti. Because in California, if let's say you died with the trust and you had an asset outside of the trust that's worth $100,000, worst case, you wait 40 days, you get a certified death certificate, you can get that asset transferred over without going to probate. So probate court, there's like a little wiggle room. So if you die less than 188,000 outside of your estate, you have to wait 40 days, get a death certificate. So the biggest areas I've seen are you create a trust, and you put all your assets into the trust, right? So you put your house into the trust, your bank accounts. But like 10, 20 years ago, we had a lot of elderly people who didn't trust the banks because they grew up during the Great Depression. They didn't trust FDIC. So they would have like 25 different bank accounts. Then they would die. Then 20 bank accounts would be in the trust, and the other 5 would be outside of the trust. So you had to deal with those assets. Sometimes you have a partial probate. And so for me, I put everything into the trust. Then the last page of my trust has a Schedule A. It says any and all bank accounts, whenever owned, any and all real property. So if you do die and you had a property you never put into the trust, that catch-all provision will catch it. So all you have to do is file a petition with the probate court. It's called a Hegstead petition. You can get that asset transferred back to the trust without going through probate.
Is that the pour over will?
Yeah, it's kind of like a pour over will, but you have a pour over will that can catch any asset that goes outside of the trust and puts it back into the trust. Or you could do a Hegstead petition if you have a really good trust with a really good Schedule A that describes all your property and any and all other property. So like I said, there's probably about 12 different documents. And so if you want to go like more in detail into a particular document, we can do that. But generally speaking, I just want you to think that there's 2 big areas of estate planning. There's incapacity and there's death. And so estate planning, like advanced healthcare directive, power of attorney, trust, they work on both worlds. Because here in Marin, conservatorship cases have gone up exponentially. Our court staff have remained the same. I think our filings have gone up like 30 or 40%. We still have the same court clerk, one judge. So our calendar keeps on getting backlogged. Why? Because people don't have an advanced healthcare directive, they don't have a power of attorney or a trust, or they're fighting over other issues. Oh, no.
Let's repeat the question.
So the question is, should the lawyer be the agent on the power of attorney? I say no. There's been a big clash between, I consider myself a younger attorney and older attorneys. A lot of older attorneys would see, hey, when Ethel dies, Matt Harris is going to be the trustee of the trust. It just looks bad. So if a person doesn't have like a family member or somebody they trust, it could be a CPA, it could be a professional fiduciary. Last case resort, I will be a trustee, but I do everything in my power not to be a trustee. Because my job is to advocate for my client. So it's hard to be an advocate and a fiduciary. It's kind of like an inherent conflict of interest, in my opinion. So I don't recommend it, but there are attorneys who are trustees. And there's issues about, do they get paid trustee fees or do they get paid attorney's fees? And it gets, but like I said, it depends. You know, if you have a trust, let's say when somebody dies, you got to pay off the final taxes. There's going to be distributions less than 6 months. Yeah, maybe an attorney could be a trustee. But some of my trusts go on in perpetuity. They go 10, 15, 20 years. It depends on your family dynamics.
That's why it brought me up here. I can clip the stuff back. Maybe I'll have to hold it. There you go.
Matt.
Yeah.
Let's say we have our estate plan trust in place, our assets are in there, whatever it is, a home, a vacation rental, whatever. If and I'm still alive, but something happened and I'm sued, can the creditor or whoever is suing me, can they get at my assets in the trust?
Yeah, repeat the question. Yeah. So if somebody the question is, so if somebody created a trust and they put assets into that trust, can creditors still go after it? So a standard like revocable trust. So the word is, if you have dominion and control, if you have control over your assets, like for example, a revocable trust, the creditors can come after you. They can, yeah. So a lot of people think, oh, I put in a revocable trust, I can't be sued. You can be sued. So California is very friendly for creditors. That's why some people go to Nevada, they go to Wyoming. They create those out-of-state creditor protection trusts. So revocable means you can change it anytime. You can amend it anytime. So your revocable trust is revocable. You can change it, amend it. So what's your name? Roberta. So you create the Roberta, whatever trust. It's revocable. So 5 years from now, you want to amend it, you can change it. But then when you pass away, that revocable turns into irrevocable trust. So, but you know, for people with larger estates, there are irrevocable trusts where you put assets into that irrevocable trust. You give up that dominion and control for generally creditor protection and tax reasons. But yeah, there's hundreds of different types of trusts you can create. But for like a family trust, revocable trust, pretty straightforward.
Should LLCs be put in a trust?
Should LLC be put into trust? Should property be put in an LLC, right, is the question.
Well, if your property is in an LLC.
So LLC is like a limited liability corporation. So LLC is, you create like a business entity. What most estate planning attorneys do is they put their family personal residence in the revocable trust. And if you have like a rental property or 2 or 3, you put those rental properties in an LLC. And so remember like 10 years ago, they had that horrible Berkeley balcony collapse? All those Irish college kids died, right? That was owned by, I think, BlackRock, but that building was an LLC because it was asset protection. So if you put that in particular house or that property in the LLC, something happens, somebody slips and falls, they die in the property, they only go after that asset into the LLC. So I got a question the other night. Hey, I have 5 properties. I put all 5 properties into one LLC. I don't recommend that. I mean, generally speaking, because you're putting everything into one big nest egg. So if your nest egg is bigger, creditor can go after. So you can kind of bifurcate different LLCs.
So,
But that's complicated estate planning.
so would you put the LLC in the trust?
In the trust,
Yeah.
you can assign you can assign the interest of the LLC. So the LLC is a separate entity. So you can assign the income and the principal to the trust, generally speaking. But I don't put an LLC into the trust. Yeah, it's separate. Yeah, show control.
So you can put your real property should go into the LLC versus your trust,
If it's
or
yeah,
depends.
it depends. Yeah, rental properties. You have 2 options. You can put a rental property in LLC, or you get lots of insurance. Well, we all know with insurance, right? They can deny your coverage, deny. There's all these carve outs, exemptions, exclusions, and the other bad things I hear about. Oh, I got to pay $800 a year to the Secretary of State. Well, it's an LLC. You know, there's asset protection there. So $800 is not the end of the world, versus an insurance company that can deny your coverage. So
Maybe a follow-up question to that is, what advantage or disadvantage would an LLC be in your trust?
but like it depends on my client situations. I've had clients who've had multiple properties. So we put their primary residence into the revocable trust. We put their rental properties into different LLCs because it's basically asset protection. We're separating all the nest egg. So if they get sued on this particular property, they go after that asset. Only, yeah. That's why LLCs. That's why you see a lot of people of residential properties are in LLCs. Any other questions or?
Is there such a thing as a legacy trust?
She asked if there's such a thing as a legacy trust.
Yeah, legacy trust is like they coin it as a dynasty trust. And so it's people with larger estates where they can hand down their assets over multiple generations. So I don't want to get too complicated. So each one in here, each person in this room has a credit of like 13 million. Married couples around 26 million. And so if you died as a married couple and you have over 26 million, then there's gonna be like some estate tax liability. Most married couples are under that exemption, so it doesn't apply. And so if you have a large estate, you have your individual exemptions, you have married couple exemptions, you have something called a generation skipping transfer tax exemption. And so you'll see legacy trusts, dynasty trusts use that GST exemption. Because a lot of millionaires and billionaires back in the day, they would give their money to their grandkids. They would skip a generation, like, oh, I'm going to avoid all these taxes. I'm going to give all this money to my grandkids. I think it was in the 1930s, late 30s, Congress said, oh, no, if you start doing that, we're going to apply a generation skipping transfer tax. And so now there's a credit. There's a GST credit and there's an individual credit. Yeah, so Prop 13's been so the question is, how does Prop 13 affect estate planning? It's really big now. Prop 13 is a parent-child exemption, and a lot of parents, they want to give their homes to their children. And let's say, I always use Ethel as my example. Ethel bought the house for $100,000. She's paying $3,000 a year in property taxes, if that. So if Ethel gave that house to her son or daughter after she died, then the son and daughter would get that low tax basis. So the son and daughter will only pay like $3,000, $4,000, $5,000 property taxes. So that's a big one, but they changed it. They took a lot of Prop 19 out. So for that to apply, the child needs to move into that parent's house, usually within a year after the mom and dad passed away, to get that exemption. I would define it. I would define it. So I've had issues where the parent said, okay, when I die, my house goes 50-50, the son and daughter. Then son and daughter, when mom and dad died, says, usually one child will say, I don't want the house. I just want half a million dollars. I just want the cash. And the other child would want the house. So there's ways that we can have the trustee obtain a loan on behalf of the trust and to pay off that beneficiary so that one child who wants the house gets a parent-child exemption. But that's advanced estate planning. Yeah.
Go.
You're not sure. But if I name it,
Well, the question was, how do you define a gift to multiple children 5, 10, 20 years from now, right? So welcome to my world. And so I deal with people who come in and they try to cram every condition into their estate plan document right now. If this happens, I want this. If this happens, I want that. I say, okay, I'll do that for a little bit, but I always say, hey, this is a revocable document. It's flexible. So I always say, review the document after a couple of years. If you want to make an amendment, let's do that. But yeah, that's what keeps me up at night sometimes at 2:00 in the morning. I try to think about all the conditions that can happen. And like tax laws, the tax laws are going to change another, 5 or 10 times the next, probably during my lifetime.
I just want can you hear me okay? Sure, a story right along what you said. So, this thing is up, but so when my mom passed away, I was the one that had to be the trustee of the estate, and I did hire, even though I read trusts all the time, I did hire Matt to come in and take care of everything. But when it came down to the house, our family home, right? It wasn't defined in there, which was fine. All the assets split right down the middle to me and my sister. It was very black and white. But my sister's husband, okay, who's, for lack of a better word, he's a little bit of a loser, okay? Let's just be frank. And so he thought that because of of what I've done myself, which is I bought multiple rental properties, that we were just going to be partners on that, and that Rick was going to be the one to take care of everything, while my sister, who's only worked about 6 months in her life, they would just go vacation. Well, they're still vacationing, don't get me wrong. But what it came down to is I said, well, here's the deal. I said, you buy me out at whatever price, we'll get 3 appraisals. I'm fine with that. I buy you out, right? Or we sell it on the open market, right? Because and that's to say, and that's what it came down to, whoever the trustee can do, because it is kind of liberal. The assets go down the middle, cash goes one way and cash goes the other way, and the house gets split down the middle, for lack of a better word. And then you just have to kind of just say, do you want it? Do you want it? Or do you want it? And what do you think a fair price is? And that's where you, like, when you were saying, like, define it for later on in life, it's really hard, because Matt started off early on saying, there's only one person in this room I know who knows when he's going to die. It's this gentleman back here. So that's what I'm saying is, if you've defined it, then you may not know, at that moment, say, oh, geez, today's the day. Like, I was going to share with you, like, on the durable power of attorney for healthcare. When my mom, this one right down here, the advanced healthcare. I remember my mom had been in and out of the hospital, and I knew, I knew when the day that it was going to be. But then when the nurse comes in and says to you, all right, let's talk end of life. And I just said, I'm not going to be the one to have to make this call on my mom, right? I'm like, this was not done. Matt had drafted the documents, and I said, there's a healthcare directive, and I know you have it because I sent it to you. And they said, well, we have it nowhere, right? Somewhere it got lost in all of Kaiser's system. I said, well, that's not a problem. I know the attorney who has a copy, and I know exactly where it is, and I also have one on my phone. How would you like it, right? So we got a copy of that document to the doctor. We all read it together, me, my sister, my aunt, both of our spouses, and it said in there, if she could not return to her normal way of life, right? Her normal way of life. And it wasn't a great life. I mean, she was wheelchair bound for many years, and they said she's never getting out of bed again. I'm like, that will be a sentence to my mom that she does not want, right? Because she loved to travel, and she would go down to the desert and back and forth. And I just said that this isn't going to work. So she made her decision. I did not have to do it, right? That goes right down to those legal documents that he drafted, right? But there was so this is where things can go a little bit wrong also with my mom's estate, and this is where because I'm on her about this stuff. She forgot to retitle one asset, and it got locked up for about 8 months, and it was a stock account, and the stock market went down, down, and down, and down, and that probate would have looked cheap, but because the investment company wouldn't release the funds, there was nothing we could do because we had to wait for the petition to be filed. It all worked out fine, but it's very important on the titling of this stuff, right? And knowing where those documents are most important. So I just wanted to share that a little bit.
That's a really good point, that you have to fund your trust and you have to have everything titled appropriately, or that's a classic example.
Oh yeah, no,
Well, this is are you ready to?
Sure. I mean, mine's the one that's going to put everyone to sleep talking about long-term care and stuff like that. But
Well, let me introduce you. This is Rick Roman. He is, do I have the screen on? Okay, good. I'm trying to make it so the people on Zoom actually can see who's speaking. Rick's been a certified financial planner and a insurance specialist since 2006. His combination of experience, professionalism, and access to a wide variety of products and services help his clients meet their financial goals, estate strategies, and insurance needs. Whether preparing for milestone life events like retirement or college, or whether you're simply looking for life, disability, income, or long-term care insurance, Rick offers a high level of attention, insight, and capability so you can achieve your goals. So with no further ado, can we please welcome Rick Roman?
Thank you. Well, I'd say that, you can offer long-term care insurance and stuff like that, but that's not really a thing anymore because it's really not available for a lot of people because just all the companies have exited the business. So, and if any of you have a long-term care policy, does anyone have one of those things? Have you gotten a rate increase or a few of them? Yeah. Okay. Good. You're one of the very few because on my own personal policy. So I got one when I was 43 years old. Because I thought, well, you know what, I'll buy it now, because truth of the matter is I'm a mountain biker, scuba diver, abalone diver, these things running, anytime I could go down, right? For me and my wife. And I mostly did it because my wife's a stay-at-home mom, right? And if something happened to her, because in her family, there's a history, I would have to stop work to take care of her or just pay for it out of pocket. So that was a way of protecting both of us to do that. And happy to say our son's 17 now. We haven't had to use it. So happy about that. But the planning side of it is my thought behind long-term care, and it's not insurance by any means. It's just having a plan and somebody knowing what that plan is. Okay. If that plan is go to my bank account and use that money, perfect. I'm good with it. Let that person know, that you've got that, that's the plan. If it's, I have a long-term care policy like you do, right? Is know the details of it or contact your insurance agent because there's a lot of weasel words in there, which I refer to because these big institutions have teams of lawyers that just sit back in dark rooms and draft, documents and make sure that they can weasel out of claims. And I had a flooding up at a house and they told me that it came through the walls. And I said, well, why is the ceiling coming down? And they said, well, you know what, we're still not covering. And after several months, they sent somebody up there in the middle of summer and said, oh, we can tell that it came through the roof. I'm like, it's dry now and it's all repaired. So anyhow, there's, like I said, there are other weasel words. Just tap that. Oh, the mouse. Let me get rid of all that stuff. Let me just jump right into this. So does anyone know what Medi-Cal and Medicaid is? Yeah. Yeah. So it's poverty, right? You have to be down to in poverty, and you have to have a small amount of income that you can retain. But if you actually go into care facilities, they take that money, right? That just goes right to it. There used to be, you'll see this right here. I just actually, because I was doing a little bit of research, there's what's called a look back period for people who think that that's an option. Because I can't believe the amount of clients that I have that say, well, I'm just going to give it away and then I'll go on Medi-Cal. I said, well, you better start, because the rules used to be there was a 60-month look back. Right. So I said, well, you better give all your stuff to your kids now and let them go enjoy it, because maybe 5 years, in the next few years, you'll go on you'll need assistance. Right. So it's coming back on January 1st. So that's really not an option for a lot of people, unless, some people, it may be a good way to go. But you typically, when you go onto that, the only asset that's left is the house doesn't have to be sold and spent down before you become eligible for it. And then after that is when you become eligible. And typically on that, they tell you where care is going to be given. Right. So yeah, no, there's so many. Then there's also, like, you can get an allowance for personal care items. And there's a lot of stuff that they'll allow you to have. And the spouse actually can keep a lot more income than they used to be able to. I was looking back at, like, all the stuff, because I had going back to like 2003, looking at all the articles I had saved and all the different changes, because, one thing that Matt had brought up was, you need to be, updating your estate plan, right? You need to be looking at these sorts of things as well, because, benefits come and go very quickly, and you don't know what it is in the year that you may need it, right? I've never had a client actually successfully go on Medi-Cal. It just doesn't work. Yeah.
Have you heard of or worked with some attorneys that specialize in helping you qualify for Medi-Cal?
I have not. Like I said, I don't have any clients that would qualify for that. So I really haven't had a need. I'd have to hit Matt up and ask him for a recommendation, because I just don't know any that do that sort of stuff.
Okay. Thank you.
This right here, and my CPA left. She was sitting back there, was Matt's wife. So years ago, I had a client. The spouse was about 15 years younger. She's still a client today. And John was a retired thoracic surgeon. I put a different name up there, but John couldn't get a long-term care policy. He had an IRA. They had a beautiful home that was all paid for. It was 4 stories was the problem. And the main living started on the 2nd story. And then they had some life insurance policies with a bunch of cash value. And so the first thing that everyone said they went to first, because the only readily cash available that they didn't think was taxable, was, hey, let's get all that money out of the life insurance contracts to pay for other care. And I said, well, I believe this is the rule, is that you're allowed to take money out of, that any time above your adjusted gross income, it gets above 7.5%, then it becomes tax deductible to you against ordinary income. Okay, so what we did was I said, well, his bills went from $5,500 a month, which was manageable, to like $15,000 to $17,000 a month very quickly. So what we did was I said, let me talk to the CPA. I brought him in. I said, hey, here's what the bills are. John needs the care. I'm like, is there not an offset that we take that money out of his very highly taxable IRA contract where he could get the money out and then have an offset because of all the medical expenses. The CPA is like, let me figure it out. So he went in there, came up with a calculation, and we were taking out close to $180,000 a year. He wasn't have to pay any income tax on it. Zero income tax. So that's kind of like, if you think about when you take money out of an IRA contract, how much money or how much you have to pay in taxes, right? And sometimes you're forced to take it out because they say you have to take it out because of your age. But having that was kind of like getting like a 40% discount because that money was going to be leftover taxable for his wife anyhow. And what happened is when John passed away a couple years later, life insurance came in tax-free and filled everything back up for her. So not, like I said, when I say you have a plan, well, it's not up there, but you just need to know that there's always there's kind of like that ant mentality is sometimes, it's not the direct route. You have to find ways around, the tax code is big, but things like that are out there, and they just say, they don't say you have to play by those rules, but they are there for you to take advantage of as well. How does this go back on? Oop.
Oh, you want to go back one?
Oh, no, how does it get turned back on?
Oh, sorry.
Yeah.
Oh, on the screen.
Yeah. Sure. Yeah. Well, so I have an estate and business planning department through my company. So that's all they do is they're constantly they're updating us. Like right now, everything is about the one big beautiful bill, and I'm getting primers on that stuff regularly because that's all new. And I learned from there was a guy, I don't know if you probably wouldn't know him, but his name was Bill Cruzy. He was an attorney here in San Rafael. We were in the Albert building when I started. And he said, if we ever left, he's like, I'm coming with you guys. So we moved our offices up to Novato about 20 some odd years ago. And he came along, and I got to tell you, so he had what became our conference room. And I'd go back there, and he would go off to the Hawaii Tax Institute, and he would sit there and he'd read this stuff. And he would bring back the primer. Well, the primer is usually about 1 inch. Then one year he goes, here's one. I'm like, what do you mean one? He goes, and here's the other one, because there was that many changes in 1 year. So you have to rely on other people, because I'm not a CPA. I'm certainly not an attorney. But I do know where to get those answers when I need them. And when you say, finding out that stuff is, my clients expect me to be kept up on everything. I'm not going to be perfect on everything, but if I hear something, right, I know in the back of my mind, okay, I know where it came from and I know where I can get an answer. So, right here, these are just the basic types of insurances that are available today, or some available, some not. One that gets often overlooked is that middle one there. It says accelerated death benefits. A lot of life insurance policies, a lot of old life insurance policies, they just added those right into those contracts, and people didn't even know they were part of it. What the accelerated death benefit says is if you had a $100,000 life insurance policy, for example, and you needed care or you were chronically ill, they can front you some of that death benefit to start, right? Typically up to like 50%. Nowadays, they're still available, and they're starting to be a little bit more liberal on there, but you have to pay for that rider to be on there. But a lot of these old contracts, it's just built right into them. And then, some of the other ones, a lot of these right here, those two, a lot of those, how those work is that if you've upfront
Rick,
put, yeah.
Can you say which two for the people?
Oh, sorry, yeah. The hybrid life insurance policies and annuities that are sold today. A lot of those, they're for someone who can't get some coverage, they say, I just want to have it. That's fine. But how a lot of those work is that if you put in a bunch of money up front, okay, basically the contract says is the first dollars that get used are your money, right? So they say, okay, you put in $100,000, the first $100,000 used is your own money, and then the care kicks in after that, right? So when I look at that, I'm like, well, I just have a hard time with that, because they advertise them a lot with like, hey, they have all this care and all this coverage, and then death benefits the end and all this stuff, and they look great. But again, you gotta read these contracts, look at those weasel words that are in there, because typically it's your money first and your death benefit for your children or grandchildren, whomever. So you got to pay attention to those sorts of things that are on there, because to me, if you look at the national average, and everybody's known people that have been on long-term care for a long period of time. My mom needed it for a decade, right? My stepdad needed it for 3 years. The typical person, typical male, is on care like around 80 some odd percent. This was a MetLife survey. But 83% of males only use care for 2.25 years. And then they're gone. Females, right around 3.5 years. And I've had that client I talked about, John, he fit right into that mold. I had another one, Nini, up in Granite Bay. She went down. All three of her siblings all had Alzheimer's in their early 60s, but we made sure that there was a long-term care plan for her, and she went almost 4 years, right? And that was the length of the policy. So if you have to have one of them, well, they're not up there, but if you have to have a plan, my opinion is don't over-insure on it. Treat it like catastrophic insurance, because you may never use it, right? You may never use it. Yeah.
Rick, I've heard that if you're in your 70s, long-term care is not available to you. Is that correct?
Yeah, and if it is, it's going to be one of those types of plans where it's all your money up front, right? And then if you live past the average, then the insurance would kick in after that. But so I mean, it typically what happens is because they know you're so close to maybe needing it, right, versus not needing it, that they price it that way. So, and basically, and then kind of like what Matt had mentioned, is like, everybody's a little bit different. It's not just a blanket, don't do it, right? Sometimes it's you're doing it for asset protection. Sometimes there's other reasons that you just, like I said, some things I can't get past is people just say, I want to have it and I got to have it. And I say, okay, if you have to, I'm like, here's someone that you may want to look to get it, because I'm not comfortable with it. If I have it, oops. I'm not sure this one. You ever heard of these? Reverse mortgages? Yeah, to me, I look at it as the last stand. I remember that attorney I told you about, Bill Cruz. He's passed away since, but he brought one of these early versions of reverse mortgages into me. He says, can you let me know how much this thing is costing? And I got to tell you, by the time I got done dissecting that thing with all the various spots of what interest were on there, it was close to 24%. So they were going to give you money, like a credit card, right? If you didn't pay your credit card bill, and basically charge you 24% interest, but on a larger sum of money. So basically what's happening is you're giving up the home, right? And I'm not going to say it's not bad, because there's some certain situations where there's no heirs, right? You know what? It can give you a lot of financial freedom, allows you to stay in your home for as long as you need, can provide money for care in home, right? So it's not that it's all bad, but typically it's okay. Everything else is, we're at the end and we need to figure something out. Because what happens is the day you die is they come in and say, okay, here's the contract, time to sell. Right. So that's not, like I said, it's, to me, again, when I look at everything in totality personally, and you should always look at, just don't segment one thing off. Look at everything in totality, because here's what I tell all my clients is, it costs nothing to look at something, costs nothing to put pen to paper just dissecting it. But the moment you sign on that line, right, you own that decision, good or bad, right or wrong, right? And I'd like to say that, every decision we all made it through our lives has been the right decision. But you know what? Sometimes the decision we made 5 years ago, it was the right decision at that time. So I always think about and hash out over and over again, so that I don't ever have to look back, or any of my clients say, I shouldn't have made that decision 5 years ago. And oops, we're going. That's right. This is the real last one, I should say, not the reverse mortgage, because nobody wants their kids to have to take care of them. But if you do, I would highly suggest talking with them and all, so that they don't have to figure it out for themselves. Because, a lot of times siblings don't live near each other, right? But have that discussion, have something written down, something that, kind of gives them a guide map to take the pressure off. And I can attest from having to do it for my mom and for my stepdad. And actually my father-in-law didn't have anything written down, but I had the conversation with him, and he died after his third Social Security check unexpectedly. Yeah. But I had everyone's none of not my wife, not my sister-in-law, not my mother-in-law. None of them knew because there was nothing written down, but I said, I actually had that conversation with him. He liked that, what's that? I wanted to call it. There's a certain type of wine he liked, and we'd share a bottle at least once a week. And we'd have these talks, right? So when that time came, right, I knew. Yeah, absolutely.
So the question is, should you have this talk with your adult children?
Yeah, I would absolutely do it. My son's 17. I've been talking with him about the savings accounts he has, his bank account, his investments, functions, and all that stuff. He's 17 now, and every quarter when his stuff comes in, we have that conversation. And I tell him about what I have going on with my stuff, because I want him to know, my wife knows, everybody knows what's going on, because if I'm not around, it's going to be a mess. Just because I know what I take care of on a regular basis, but I've had the conversations and I have it written out. Matt's taking care of all my legal documents, actually restated my original ones, because I was one of those, well, back in the day, I was one of those guys that drafted my own first one. And I said, well, things have gotten more complex. I need somebody who knows what they're doing now. And I had him, he came in and redid everything. He said I did it perfectly, of course. Yeah, no, but the one thing that I can say for sure is make sure that you have something written down where somebody knows where it is, right? Or if you have adult children, talk with them, because sometimes you just can't put it on paper either. Any questions?
So you're a insurance broker, agent type of thing. So what types of insurance products do you represent?
So for a lot of times, like I started off my career as like just an insurance guy. I've been investment licensed since I think August of 2011, I believe it is. So that's my 25th year in investments. But we did a lot of just gravitated towards a lot of estate planning for higher net worth people, which way back when the estate tax issues were a lot different, meaning that you could shield $1 million and everything above that was going to be subject to 55% estate tax, right? So a lot of people had a lot of issues, right? So since then, things have changed drastically. Like Matt had mentioned, is one thing that is constant is change, because we know in about 3 more years, whatever administration comes in next, there's going to be a lot more change, right? They're already drafting, the second, they call it the mini big beautiful bill, right? So that's coming too, right? So we know more stuff is coming. So change is constant. So I did start with a lot of insurance early on in life. Since then, I've gravitated towards the investment side, because that's what I actually have more of a passion for. We have probably almost $1 billion of insurance in force. There's a lot of insurance. So if all my clients died, there's going to be some upset insurance carriers. But nevertheless, we've paid out claims, and some of the most meaningful claims are, people who are starting out, and then all of a sudden the patriarch of the family is gone the next day, right? Or if somebody becomes disabled. I've only had a few people where they go early. So I always tell it to my clients to say, you know what, you're good if you get a permanent insurance policy because nobody ever dies. I'm like, they just keep going. We have one of our clients, original clients, turning 100 in January. And we thought he was going to go, but he licked it. But so I don't do any property and casualty. I am licensed to do it. My thing's always been, if I want to learn something, I'll just go get a license, and I'm forced to learn it. Right? I don't do it. I don't sell any of that. That's not something I do, but I understand it very well.
Rick, I'm really not following your. I'm really not following what it is that you do. So when you say investment side,
Yeah.
what is that? So if I were to come to you as a client, what am I looking for from you?
So I'm a certified financial planner, and I have been since 2006. So that means that whatever you have, I'm going to look at it all, right? So I'm going to look at your property and casualty. I'm going to review your investments. I'm going to have your estate documents reviewed, because I just don't say, okay, I'm just going to look at the money because that's what I get paid on. I get paid to make sure that my clients, whatever they want done, right, gets done properly. So we review everything before making any recommendations on whether it's investments or insurance. It didn't. Okay.
So Rick, you and Matt work closely together, or separately, or just
separately. Yeah.
But when needed.
Yeah. So when I have somebody who needs an irrevocable trust, a regular trust, all their legal documents to start, I introduce them to Matt. And if they need a CPA, then I introduce them to them as well, because it takes a team approach. Like I said, I'm not a licensed attorney. I'm not a licensed CPA. I understand that stuff very well because I had to to pass my exam. But when I'm doing financial planning, when it's not just specific, like I'm just going to be just the investment guy, right? I look at everything holistically to make sure that everything is working together. Because just for example, like my mom's own estate plan, she had bulletproof estate documents, one asset titled incorrectly, and it was a $300,000 mistake.
So if we want to contact you, type of thing, can you kind of walk through what I could expect by calling you?
Yeah. So what we would do is we would set up an initial meeting, right? I'd ask you some questions first before, to make sure that you taking the time to come into my office made sense. Nothing personal, right? Just to see what your goals are going to be, what matters to you. And if I see that there's some way I can help you, then we invite you in, and then just ask you some questions, right? About 50 minutes, no more than that, because I do understand that kind of like this meeting's getting a little bit long right now, right? People tend to get glossed over. I love talking about finances, so I can do it all day long, which I do. So we have an initial meeting, show our process, and then if it's your choice to decide if you want to move forward. If so, we give you a list of documents that we need to have reviewed, and then on the next meeting you bring those in to us. We review them, ask you questions through those as well. And then from that, we would put together a plan of these things that we would say, okay, here's what I would recommend that you do, X, Y, and Z, right? I'm a big fan. If it's not broken, don't fix it, right? If it's just fine, I have no problem, because I've been doing this long enough, and I've got a nice client base that I can say, you know what, you're just fine.
I was going to ask Matt the same question.
Well, he's not gone. He's hiding back here.
That I just asked you.
All right. What's the question?
What's the process if they were to come see you?
Right. If I were to come in and say, "Hey, Matt, I'd like to see what we can do," type of thing. So could you just kind of give me an overall of what to expect?
Yeah, normally what happens is I get a phone call or an email from a prospective client, and I'll talk to him or her over the phone for like 5 or 10 minutes. I'll ask them if they're individual, they're a married couple, do you have any kids, do you have any property? What I like to do is I like to email that particular questionnaire to that person first. Then when that person fills it out, whether it's an individual, married couple, then when we go and meet at my office, I'll have that document ready because that saves a lot of time. Then I can see that person's particular family dynamics, their assets, their liabilities, their needs, their wishes, and I could start brainstorming what type of a plan to create. So that's a typical process.
Pricing all over the place.
Mhm.
For $1,000, $8,000, all over the board.
Yeah. For me, it's no secret for like an individual estate plan package is around 2,500. A married couple is around 3,500. That assumes like one property. That's my typical ballpark. That's usually a flat rate fee that includes all notary fees, recording fees. Obviously, it might change if somebody has different assets, more properties, but generally speaking, it's 2,500 for individual, 3,500 for a married couple. And I would say if somebody doesn't have an estate plan, whether it's a conservatorship or a trust matter, my initial retainers are around $5,000 or $10,000. So just because somebody didn't have an estate plan, it created a big problem down the road. Bigger problem.
We have, if I have one in place, would you review the estate plan that I have and take it from there, or would you start fresh?
It depends. I review estate plan documents all the time. So the big year was 2012 when we had a lot of tax law changes. So I always ask, hey, was your trust created before 2012 or after 2012? A lot of times before 2012, I review it. Yeah, a lot of trusts are good. A lot of them are bad. I've seen trust documents that are 3 pages, which is not very good in my opinion. My documents are around 40 pages. So I've seen a 3 page trust. I've seen trusts that are just terribly written.
Well, to be perfectly just frank with you, Matt, is that we as lay people don't know if what we have in place is sufficient because we're getting different takes on it.
Yeah. So you kind of get what you get sometimes. I've been
Well-
around for 13 years individually. I worked for other estate planning attorneys for an additional 10 years. My name is my practice, so I stand behind my name. So I'm not some big corporation. I take pride in what I do. Obviously, Marin County is small. You got to protect your reputation, especially with the judges, with your fellow colleagues, and yeah, that's what I do.
Okay, I'm just giving you my bare bones. I mean, it's not like I'm not willing to pay, but doggone it.
It's awesome. I feel like I'm on a podcast. I like it.
Is that
Any other questions? So the question is, if I were incapacitated or I died, what happens? I do have business succession planning. So if I do die, obviously the state bar is notified. Then my personal representative would have my client files and would contact that person. About 2 years ago, I had 3 of my colleagues here in Marin County, their estate planning attorneys, all died within a short amount of period. I took over one of their practices, and it was challenging. But yeah, that attorney died. I took over his clients, and yeah, sometimes I get the phone call. Hey, I had an attorney 20 years ago. I don't know where he's at. I'll tell my prospective person, go to the state bar website, or sometimes I'll try to help locate that attorney. And a lot of times the attorney died, and usually you're dealing with that attorney's husband's or wife, who's usually the personal representative. For me, when I create an estate plan, I give my client the original estate plan document and a copy. I'll always have a copy for my records. So if I were to die, that particular client would have to find another attorney. Yeah. So the question is, do I help my clients fund the trust? I fund the house. So I'll take care of the deed. I'll deal with the recorders. I make sure the house is held in trust. With bank accounts, generally speaking, that my client can do it on their own, but if they need help, I could charge them, an hourly rate, maybe an hour of my time, but It's pretty easy nowadays online to transfer your accounts into their trust. So I have a document. It's called COIA, protects me. So I send when everything is done, I send your estate plan binder to my client, and I have a letter, explaining what to do, what not to do. Very big up front, trust funding letter. This is what you need to do. I'll remind my client what to do, what they need to do. But generally speaking, I'll deal with the real property. I'll put it into the trust. I'll give my client a copy of the recorded deed, and they will, handle the accounts on them by themselves. But I have a letter that covers me from liability because a lot of the older attorneys back in the day, I knock on older attorneys, but they would create trust for clients and they'd say, okay, bye client. And they go off into the world. Then a lot of those clients died and they never funded the trust. Then they have that Schedule A, which is that last document to the trust that will say $10 cash. Like, what does that mean? So my Schedule A, I cover all the property, your real property, your bank accounts, any and all bank accounts. I make it vague for a reason. So if you were to die and you omitted an asset, I say, oh, hey, Matt had the intent to put that asset into the trust. He messed up. He died. He never did it. Your Honor, we can avoid probate because Matt had the intent to do that. Look at the Schedule A. So you get what you pay for sometimes, right?
A lot of commercials out now about losing the deed to your house without you knowing, a scam thing.
Yeah.
But if your home is in your trust, is it protected from anyone being able to get to it?
So the question is, if your home's in your trust, is it protected from anyone getting to it? There was a story about 5 years ago where someone fraudulently conveyed a deed for the Empire State Building in New York. It was a fraudulent conveyance. So good thing about real property, you physically can't pick it up and steal it, right? It's a house. There's always recorded documents. I do a lot of financial elder abuse litigation, and the number one area are homes. So I go back to the recorded deeds. I'm like, oh, look at this right here. You gifted this house for no money. What are you talking about? Oh, it was a purchase price. I bought it from that person. I'm like, oh, how much did you buy the house for? Oh, I didn't give that person a purchase price yet, but you already took the house. So a lot of times, like Miranda APS will call me. I'll go out there, Adult Protective Service. I'll go out there and I'll interview. I'll look at everything. Oh, this is not right. Doesn't smell right. Doesn't look right. And end up in probate court. Usually getting an elder abuse restraining order, filing some kind of elder abuse action. It's happening a lot in Marin right now.
Thank you all for coming today, both here in person and on Zoom. And thank you, Matt and Rick, for your presentation.